If you're over 40 and you just received a severance offer, federal law gives you something most employees don't realize they have: a mandatory 21 days to review the agreement before you're required to sign anything. Hi, I'm Michael Harmon, a North Carolina employment lawyer, and I want to explain exactly what that window is, where it comes from, and why it exists. Because most employees either don't know about it or they don't use it the way it was intended. The protection comes from the Older Workers Benefit Protections Act, a federal law that was passed specifically because older workers are statistically more likely to be targeted in layoffs and reductions in force. Congress recognized that employees over 40 needed additional time and information to fully understand what they were being asked to waive before signing away their legal rights. The 21-day review period is the result of that recognition. During those 21 days, an employer cannot legally pressure you into signing faster. Any attempt to shorten the window, create artificial urgency, or suggest the offer will be pulled if you don't sign immediately is legally problematic. The 21 days belong to you, and the law protects your right to use every one of them. What those 21 days are actually for is understanding what you're giving up in exchange for the severance payment. The general release in most severance agreements waives every legal claim you have against your employer, including age discrimination claims under the Age Discrimination in Employment Act. That is a significant waiver, and it's the primary reason the law gives older workers extra time to consider it. An employee who was passed over for retention in favor of younger colleagues, paid less in their final years, or pushed out in a way that was connected to their age may have a viable ADEA claim, one that disappears the moment they sign the severance. There's also a 7-day revocation window after signing. Even if you sign the agreement before the 21 days are up, federal law gives you 7 days to change your mind and revoke it. The agreement doesn't become final and enforceable until that 7-day window has fully closed. That protection also cannot be waived. It exists regardless of what the agreement says. The combination of the 21 days to review and the 7 days to revoke is one of the strongest employee protections in the federal employment law. It exists because the stakes of signing a severance agreement without understanding it are significant, and because the pressure that often accompanies a job loss can make a careful review feel impossible. The law removes the ability of an employer to use that pressure against you.